Hey y'all, Rob here with ATX Legal, and today I'm going to talk to you a little bit about drug possession in Texas. First, a little bit about me. I'm a criminal defense and personal injury attorney here in Austin, Texas. You can find my website at atx.legal. And just a little disclaimer, this is not legal advice. If you would like legal advice on your specific case, just give us a call or visit the website. So if you're like me, you probably feel like drug laws just in general are a little too harsh. I don't think we should be charging people with felonies when they have an addiction and they have problems, and then we saddle them with a felony for their whole life. A lot of people have that view. Maybe you do, maybe you don't. We can probably be sure that we agree that in the war on drugs, drugs are winning. So politics aside, I'm just going to kind of get into the nitty-gritty of what the drug laws do and how to best fight drug charges when you have them. So this is kind of from the perspective of someone who is charged and how to handle your case. Okay, as far as how drugs are going to be charged, whether it's a misdemeanor or felony, there's a huge variety. It's going to be based on the amount of drugs you have, the type of drugs, and then other factors like, are you being charged with manufacture and delivery? Like, for example, if your drugs are all in little baggies, or are they instead for like personal consumption? So instead of trying to get into the specifics of every single drug, which would actually be impossible for a video of this length, I'm going to talk more in generalities. Even when, I don't have all this stuff memorized. So when I get a case, what I do is, look at what they're charged with, cross that with the evidence, and make sure they're charged with the right thing, because guess what? Prosecutors make the mistake too. I even had a case recently where someone was charged with a felony and it was supposed to be charged as a misdemeanor based on the amount and type of drugs. So obviously that has a big impact on your case. So it's important that I don't go from memory. If I think it'd be malpractice to go from memory. In fact, it's kind of strange when we take the bar exam, we have to memorize all these laws. When in practice, it's almost malpractice to go from memory. You should be looking these things up. In Texas, you have 4 different penalty groups. Penalty group 1 is going to be the most serious. That has stuff like heroin, meth, drugs that don't have any medical purpose. So there are some things in there that you might not expect, like psilocybin. But for the most part, these are the more serious drugs that you think of. Then going down, you have penalty group 2, which has substances like ecstasy and PCP. Now, see, PCP I would put in 1, whereas I'd move psilocybin maybe down to 2 or 3, but that's how they have it. And then moving down to penalty group 3, you have drugs that are can be prescription drugs, so benzos, Xanax, and then penalty group 4 is kind of more of the same, other drugs that are prescription. So again, I'm speaking in general terms here. The thing that I do is when I get a new case, I look at the drug test. So they'll test the drugs. They'll, initially the police might say, oh, this is a white powdery substance, and in my experience, it's cocaine. But they will send those drugs to a lab. It'll take a few months, and they'll come back with a lab test as far as the chemical makeup of the drug. So I'll take that lab test, cross-section it with the code, make sure that it's charged the right way. And if it's not charged the right way and it works in our favor, I'll definitely be bringing that up to the prosecutor so we can reduce those charges before we even get started fighting the case. Marijuana is kind of its own thing. A lot of people hear that it's decriminalized in Austin. That doesn't mean that the laws have changed. The laws are the exact same as they were before, but the way that the police view marijuana is they're not going to cite it on its own. Sometimes you will still see marijuana charges when someone is hit with a bunch of different charges, and they'll just slap on the marijuana charge. There's nothing saying that the police can't still write you a ticket or arrest you for marijuana. It's just a police policy that they're not doing that. So be careful, even with marijuana, and especially if you get outside of Austin, you can absolutely still be arrested for marijuana. Another kind of special case is THC oil. So a lot of people think that THC oil is going to be a misdemeanor because marijuana is a misdemeanor. THC oil is actually its own thing. It's a Schedule 2, meaning it's going to be charged as a felony no matter how much the amount is. So just be very careful with THC oil. It is not treated the same as marijuana. It is not decriminalized in Austin. You could absolutely be charged with it. So just be careful there. And when you're thinking about this, prevention might be the best way to go. So just common sense things like don't carry drugs in your vehicle. Don't carry them on your person. If you do happen to have drugs in your vehicle, don't speed and do things that's going to draw attention. I'm not condoning drug use. I'm just being practical here. I know that people that are hearing this, some of you are going to have drugs. And if you do, just be very sensible about where you have them. Just be discreet. The best way you can prevent charges is just by not drawing any attention from the police. And of course, not doing things that get you so intoxicated that you're drawing attention to yourself in public, where the police are going to want to search you and they're going to be pretty sure that you have drugs on your person. So just avoiding those sort of dangerous situations is going to be way better than what any attorney can do, because a lot of what we're doing is cleanup. Now, when it comes to what are my goals when I do have a drug possession case, and I'm going to separate them out a little bit here. There's the cases where it's just a simple possession versus manufacture and delivery, which is something that I'll get to. But when I'm talking about a simple possession case, my only goal is to get the case dismissed. And why is that? The prosecutor is going to have bigger fish to fry. They're not going to want to take your case to trial. And that goes for felonies especially. Misdemeanor marijuana in Austin, that's usually going to be, you're going to take a class, that's 4 to 8 hours, and you're going to get your case dismissed. Just take the class. It's like ripping off a Band-Aid, and you can get that dismissed. With felonies, it's not quite that easy. Sometimes, the prosecutors will see if you'll accept a plea deal. Don't ever accept a plea deal that requires a conviction. If they're saying, hey, go take a class and do some community service and we'll dismiss it, that's acceptable. A deferred prosecution where they dismiss it up front, and then if you do get a new charge, they can bring this back. That's also acceptable because it does result in a dismissal. But anything that results in a deferred adjudication or a conviction is not something that I'm going to be willing to accept for my client. Why? I'll just say, okay, take it to trial. And they're not going to want to expend the resources, especially now in COVID when trials are a very precious thing. They're going to want to use those trials for people who are charged with murder, rape, aggravated robbery, things that are violent and serious. They're not going to waste resources on a felony drug possession case. So, and I think with good reason, right? We want to see people charged with violent crimes off the streets. Drug charges, even though I think that the prosecutors still see them as maybe more serious than maybe they should, they still definitely see them as less serious than those other things I just mentioned. So we can use that to our advantage and secure a dismissal when it comes to simple possession, even of harder drugs like cocaine, methamphetamines. You're still going to be able to get dismissals in a lot of these cases. And it doesn't mean you're going to get away with doing nothing. You'll have to jump through a hoop or two, but I promise you it's worth it when you get that dismissal and you get it off your record and move on with your life. And you can, once you get it dismissed too, you can get it expunged. And the thing that can really make these cases a lot more difficult is when they are charged adjacent with other charges. So for example, with methamphetamines, you're going to see a lot of assault family violence. Why? Because meth amps people up. It makes people angry. They get irrational. A lot of times people are using methamphetamines together and assault cases happen. Family violence cases happen. With opiates, sometimes, and I'm generalizing here, but it's just stuff that I've seen. A lot of times there's going to be other criminal behaviors that are associated, like theft of materials, theft of copper, things that they're doing to support their habit. And when these charges happen together, it can make the drug charges more difficult. And another thing you see often is someone will get arrested while their case is still pending. They'll go and they'll get another arrest for theft, and then tacked on with the theft is going to be possession, then drug paraphernalia, and each drug would be its own charge. So if they have meth on them and opiates and marijuana, you could see all these charges pile up, and it makes the case more difficult to handle. it makes it easier for the judge to say, okay, we're going to keep you in custody while the case is pending. And I've talked about this in my other videos, but it's a lot easier to handle cases and a lot easier to wait on a good plea deal when you're not in custody versus when you're in custody and that plea deal is saying, hey, you can get out and get on probation tomorrow if you just accept the deal. All of a sudden, you're going to be a lot more likely to accept a deal that includes a conviction. So it's very important to not get all these charges kind of piling on each other. That's the only way that I ever get forced into agreeing to a plea deal for a conviction on a drug charge. And remember, it's always my client's decision. So I can tell them all day that, look, you need to hold off and wait and we can get a better plea. But if they're in custody, I mean, I understand if I was in their position, I might make the same decision. And your key to getting out is to get a conviction, is to give the prosecutor a conviction. You might do it. So those are the cases that really get more serious. And then, of course, when people are dealing or manufacturing, those cases are automatically more serious. And those are the types of cases where I end up, or my client ends up deciding, look, we're going to go ahead and agree to have a conviction and have it on my record. But for simple possession cases, if that's what you're charged with, be very wary of any plea deal that involves a conviction. Okay, so a lot of what I was just talking about applies to just people getting charged with simple possession. Not a lot of it applies when you're charged with dealing. So how do people get arrested for dealing? There's stings that happen, usually around Arch. They'll send an undercover police officer to go buy some weed or meth or whatever, and they'll get it all on video, and then another officer will come and arrest. And sometimes they'll just cite and release. They won't even arrest. And so that can be worse sometimes because people don't take it seriously. They don't appear in court. Now you have a failure to appear in addition, and it just sort of piles up. Also with drug dealing, and this is just what I've seen, just because someone gets charged doesn't mean they stop. So they'll go and they'll get another arrest, they'll get another charge, and they can really start piling on. And especially, as I talked about, it'll be adjacent to other charges, whether that's assault, public intoxication. A lot of different things can be just sort of thrown together because once you're arrested, the officers are just going to keep on throwing more on to see what sticks, and it can make things difficult. So I would not advise anyone be a drug dealer. The money you get is fast, but then you pay for it later. So I would definitely advise you to find another line of work if that's what you're doing. And if you have been charged with it, if you do stop immediately and you don't get new charges, the outcomes can be pretty good and pretty similar to simple possession. But what I see most times is there ends up being a long history. And once you have a conviction on your record, it's going to be a lot easier to secure that second, third, fourth conviction. And of course, you get branded as a felon, and it makes the plea deals harder. And then that's on your record. It's something that never comes off for your whole life. So some people think it falls off your record after 10 years or something. It doesn't. If you've been convicted with a felony, that's on there. Unless you get pardoned, it's going to be on there for the rest of your life. Okay, so that's drug possession. Down below, I am going to link to just a chart that shows the different schedules. So you can look at if you've been charged with something, you can find the drug you've been charged with and the amount, and that will tell you whether you're being charged with a Class B misdemeanor, Class A, state jail felony, all the way up to first degree felony. Again, that's what I would look at if you came to my office and showed me what you were charged with. So good luck with your case. If you do want a consultation, just visit atx.legal or give us a call. It's completely free. I do them by Zoom. We can just talk about your case and see what the outcomes might possibly be based on the facts of your case. I do look forward to hearing from you, and have a great day.